Testing.
It just,
Well, I would love to, do you guys have a website or something that I could look at what you?
Testing 1, 2, 3, 4, 5.
Committee hearing will come to order. I want to welcome all of you this morning, and I will now make an opening statement. In Federalist Paper number 81, Alexander Hamilton described how Article 3 of the Constitution was designed to establish a system of federal courts competent to the determination of matters of national jurisdiction. To that end, Section 2 of Article 3 allows Congress to extend the jurisdiction of federal courts to controversies, quote, between citizens of different states, unquote. Cases in which, by their interstate nature, implicated national concerns. Prior to the ratification of the Constitution, our new nation was governed by the Articles of Confederation, which allowed states to impose rules that benefited their own commercial interests while hurting consumers nationwide by limiting the free flow of goods and services throughout the country. The framers of our Constitution were clear that for America to succeed, the rules had to be changed to allow the development of a vibrant national economy that could sustain the needs of all of its citizens in whatever states they might live. To that end, the framers drafted a Commerce Clause and also a clause allowing federal courts to hear disputes between citizens of different states so goods and services could cross state lines into new markets without the fear that local state officials would stack the deck against them. James Madison, in the Virginia Ratifying Convention, defended federal court diversity jurisdiction over all cases involving any citizens from different states as follows, quote, "It may happen that a strong prejudice may arise in some states against the citizens of others, who may have claims against them. We know that tardy and even defective administration of justice has happened in some states. A citizen of another state might not chance to get justice in a state court, and at all levels he might think himself injured." Alexander Hamilton also explained in Federalist Paper number 80 that, quote, "No man ought certainly to be a judge in his own case, or in any case or any cause in respect to which he has the least interest or bias." This principle has no inconsiderable weight in designating the federal courts as the proper tribunals for the determination of controversies between states and their citizens. He elaborated that, quote, "In order to the inviolable maintenance of that equality of privileges and immunities to which the citizens of the Union will be entitled, the national judiciary ought to preside in all cases in which one state or its citizens are opposed to another state or its citizens. The power of determining causes between two states, between one state and the citizens of another, and between the citizens of different states is essential to the peace of the Union," unquote. He had an opinion, didn't he? Yet the federal courts themselves, through various opinions, have narrowed federal jurisdiction over cases involving citizens of different states such that the existence of citizens from two different states in lawsuits in and of itself, as contemplated by the text of Article 3, Section 2, does not confer federal court jurisdiction. This hearing will examine whether Congress should statutorily expand federal court diversity jurisdiction to more accurately reflect the expectations of the framers of the Constitution, and to implement its federal court diversity jurisdiction clause as originally understood. So with that, I will now yield to the ranking member for an opening statement.
Thank you, Mr. Chair. Once again, we're holding a hearing that's designed to make the case that Congress should tilt the playing field in favor of corporate defendants and against those harmed by their wrongdoing. Not exactly what I live by, and not exactly what I think law should live by. We should look for the people that are being hurt and injured and give them the benefit of the doubt whenever you can. In this case, we give the mighty and the powerful every opportunity to oppress, to injure, and to harm without compensation. The hearing title is seemingly innocuous, but the ultimate goal of this hearing seems to be to advocate for repealing the more than 200-year-old complete diversity requirement, a requirement that the first Congress created and the Supreme Court has repeatedly upheld since 1806. Doing so would do serious harm to consumers, federal courts, and the fundamental balance between the national government and state sovereignty. Diversity jurisdiction is the jurisdiction of federal courts to hear otherwise purely state law matters when the parties are citizens of different states. It's rooted in Article 3, Section 2 of the Constitution, which provides in part that federal courts have the power to hear controversy between citizens of different states. The diversity statute defines the scope of diversity jurisdiction more precisely, imposing various requirements such as a minimum amount in controversy requirement, and the requirement that there be complete diversity. That is, that every plaintiff is a citizen of a different state than every defendant in order for a federal court to exercise jurisdiction over a purely state matter. This hearing seems like old wine, and not old wine that has aged well, but old wine that you should throw out in a new bottle. Earlier this year, for instance, we considered legislation that would have drastically altered another long-standing and related doctrine, the doctrine of fraudulent joinder, in order to make it easier for federal courts to exercise jurisdiction over state cases. I would oppose any attempt to repeal the complete diversity requirement for the same reasons I oppose the fraudulent joinder legislation. First, repealing complete diversity and thus making it easier to bring purely state law matters into federal court would significantly increase the workload of the federal judiciary. Not a bad thing for people to work hard, but not when there are not enough judges. This increase would impact all litigants in the federal courts, not just those bringing diversity suits, and would diminish the attention and resources federal courts could give to every case on their dockets, criminal and civil. The increased workload would stem from the increased number of cases a federal court would have to hear should it become easier to file state law cases in federal court. The burden, however, would be compounded by the high number of judicial vacancies that have resulted from the Senate's failure, absolute disregard for their duties constitutionally imposed, to act in a manner timely on presidential judicial nominations. And the first in line, I should remind, is Edward Stanton Jr., or the third, excuse me, who was the U.S. Attorney in the Western District of Tennessee, and first in line, been waiting 11 months for confirmation. Secondly, repealing the complete diversity requirement would upset the careful balance between the roles of state and federal courts under our system of federalism. I find it ironic some conservatives who invoke phrases like states' rights and activist federal judges in opposing things like voting rights or civil rights are now seeking to empower the federal courts to become substantial arbiters of state law, the power traditionally and rightly belonging to state courts. State courts should interpret and shape state laws, and instances where federal courts shape state laws are and should be the narrowest of exceptions. Finally, the increased cost and potential complexity of litigating state law matters in federal courts may result in ultimately denying those with meritorious claims their day in court. Plaintiffs have a right to choose the form in which their claims will be heard. Repealing the complete diversity requirement threatens to erode that right and add cost to the litigation of state claims, the prospect of which could result in dissuading those with meritorious claims from even filing suit. I'm deeply disappointed we are wasting our time on our limited time that we have in this Congress, in this committee, on this hearing. We should be focused on restoring voting rights. Right before an election, what are we doing on voting rights? Nada. Nothing. The courts are acting. Yeah, North Carolina went too far and joined. We're doing nothing to let people vote because we don't want them to vote on the majority side. They want to impose restrictions to limit people's power to vote and express their will. Criminal justice reform, so important. People are being kept deprived of their liberty and kept for longer periods of time than necessary at $30,000 a person. Did we deal with criminal justice reform? No. And due process for individuals who might be fleeing from a policeman, have we dealt with that? No. Are we dealing with, and this wouldn't be in this committee, but in this Congress, funding to fight Zika? No. There's so many matters that we have to come forth and could come forth in this subcommittee, but we're not dealing with them. We're finding 200-year-old statutes to attack. Repealing a well-settled law does not seem to be one of the reasons we should be here and using our precious time. With that, I say it's no more and yield back the balance of my time.
And I thank the gentleman, and it appears that we don't have any other opening statements, so with, oh, I'm sorry, Mr. Conyers, forgive me. You're just such a shrinking wallflower over there in the corner. Nobody can see you. And so I now recognize the full Judiciary Committee ranking member, Mr. Conyers of Michigan, for his opening statement.
Thank you, Mr. Chairman. I'm honored to be recognized here. I've been around long enough to be known by most of the members of the House. I take the position that the hearing focusing on federal diversity jurisdiction, whereby federal courts may hear otherwise purely state law cases if the plaintiff and the defendant are citizens of different states. For more than 2 centuries now, the Congress has imposed and the Supreme Court has upheld the requirement of complete diversity, which mandates that every plaintiff must be a citizen of a different state than every defendant for a federal court to have jurisdiction of the lawsuit. Unfortunately, based on the majority witness's testimony, it appears that this hearing may be laying the groundwork for the outright repeal of this long-standing requirement, and it represents the latest attempt by corporate interests to deny state court plaintiffs access to justice. As many of you may recall, I've long opposed any effort to repeal the complete diversity requirement for the following reasons. To begin with, expanding the scope of federal diversity jurisdiction upends the careful, centuries-long balance between federal and state sovereignty that current law has achieved. More than a decade ago, when we were considering the Class Action Fairness Act of 2005, which, among other things, eliminated the complete diversity requirement for certain class actions, I raised the concern then that the measure would undermine state law by substantially divesting state courts of the ability to interpret state law. State courts, after all, should be the final arbiters of state law. The complete diversity requirement and other limitations on the scope of diversity jurisdiction are designed to serve this important federalism interest, and repealing it beyond the class action context would only heighten my concerns, and in addition, eliminating the complete diversity requirement would increase costs and might make even litigation cost prohibitive for many plaintiffs with meritorious claims. As it is, the cost of litigation increases whenever federal courts are called upon to decide state law questions because of the added complexity and time required to resolve such issues. Eliminating complete diversity would only increase these costs on litigants with a disproportionate adverse impact on plaintiffs, who generally have fewer resources than the corporate defendants they typically face in court. Once again, our experience with Class Action Fairness Act is instructive, as the law made it far more burdensome, expensive, and time-consuming for injured persons to vindicate their rights under state law. So we should be wary of spreading this harm even more broadly. Finally, eliminating complete diversity would increase burdens on an already strained federal court system. Even by the majority witness's own estimate, eliminating the complete diversity requirement would potentially add more than 500,000 additional cases to the federal court dockets every year. As it is, the federal court system is already straining to meet its current caseload in light of significant unmet judicial resource needs. There are numerous judgeship vacancies, as well as an overwhelming need to create new judgeships that require congressional action. Accordingly, we should be especially wary of eliminating the long-standing complete diversity requirement, a requirement whose constitutionality the Supreme Court has repeatedly upheld for more than 200 years. And so I want to commend the ranking member, Mr. Cohen, for his statement, which I support, and I thank the witnesses for their presence and look forward to their testimony. Thank you, Mr. Chairman.
Thank you, sir. I thank the gentleman, and without objection, other members' opening statements will be made part of the record. So I'll now introduce our witnesses. Our first witness is Mr. Charles Cooper, a partner at the Cooper and Kirk Law Firm in Washington, D.C. Welcome, Mr. Cooper. Our second witness is Professor Joanna Shepard, Professor of Law at Emory Law School. And welcome, Ms. Shepard. Our third and final witness is Dean Ronald Wii, Professor of Law at the University of Baltimore. Welcome, Professor. Each of the witnesses' written statements will be entered into the record in its entirety, and I'd ask each witness to summarize his or her testimony in 5 minutes or less. And to help you stay within that time limit, there is a timing light in front of you. The light switches from green to yellow, indicates that you have 1 minute to conclude your testimony. When the light turns red, it indicates that the witness's 5 minutes have expired. And so before I recognize the witnesses, it is the tradition of this subcommittee that they be sworn. So if you'd please stand. Do you swear that the testimony you're about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? You may be seated and let the record reflect that all of the witnesses responded in the affirmative. So I will now recognize our first witness, Mr. Charles Cooper. And Mr. Cooper, if you make sure that microphone's on.
Good morning, Mr. Chairman, Mr. Ranking Member, and members of the subcommittee. I want to thank you for inviting me to participate in this morning's hearing on the subject of diversity jurisdiction, and I'm honored to share my thoughts with you on the issues that are raised by this subject matter, particularly the issues raised by complete diversity, the doctrine of complete diversity. Forum selection is controlled in our system of litigation, both state and federal, by plaintiffs. It is therefore no surprise and no accident that mass tort suits and other large-scale interstate disputes cluster in certain notoriously plaintiff-friendly state jurisdictions. The proliferation of complex interstate disputes in state courts has imposed massive, often bankrupting costs on major American manufacturing corporations and has placed great burdens on the national economy. Large-scale interstate disputes almost always involve adverse parties of diverse citizenship. Yet the out-of-state defendants are often locked in state court, unable to remove those cases to federal court. The cases cannot be heard in federal court because the Supreme Court early on interpreted the diversity jurisdiction statute to require complete diversity of citizenship. Thus, the plaintiffs in many interstate disputes can keep their out-of-state defendants trapped in state court simply by naming at least one in-state defendant. Now, I want to make 4 quick points this morning about complete diversity. First, the diversity of citizenship clause of Article 3, Section 2 provides simply that federal judicial power, and I'm quoting, federal judicial power shall extend to controversies between citizens of different states. The literal scope of that plain language thus clearly embraces cases of minimal diversity, that is, cases where any single plaintiff and any single defendant are citizens of different states. And the Supreme Court has held that complete diversity is not a constitutional requirement of the diversity clause. That is, Article 3, Section 2, is satisfied by minimal diversity case. Second, the requirement of complete diversity is at war with the animating purpose of the diversity clause of Section 2, which was succinctly described by Hamilton in Federalist Number 80, previously noted by the chairman, but I think it bears repeating. The national judiciary ought to preside in all cases in which one state or its citizens are opposed to another state or its citizens, for it is that tribunal which, having no local attachments, would be likely to be impartial between the different states and their citizens. Now, that understanding of the purpose of diversity jurisdiction was echoed by virtually every supporter of the Constitution in the ratifying debates. James Madison put the point a little more bluntly in the Virginia Convention. It may happen that a strong prejudice may arise in some states against the citizens of others who may have claims against them. A citizen of another state might not chance to get justice in a state court, and at all events, he might think himself injured. My third point is that the requirement of complete diversity can be traced to a Supreme Court decision in 1806, construing, actually misconstruing, the language of the original diversity provision in the 1789 Judiciary Act, which was materially identical to the language of the diversity clause in Article 3, Section 2. The decision, called Strawbridge against Curtis, was issued by Chief Justice Marshall in a perfunctory six-sentence opinion that offered no reasoning in support of his textually strained conclusion that a case, and this is quoting from that statute, quote, between a citizen of a state and a citizen of another state somehow requires complete diversity rather than minimal diversity. Marshall and a majority of the court later came to the view that Strawbridge had been wrongly decided, and Marshall is reported to have, and I'm quoting from a Supreme Court case, to have repeatedly expressed regret to his fellow justices that the decision had been made. But the case has never been overruled. Thus, the statutory requirement of complete diversity of citizenship is not one that the first Congress truly intended to impose on the federal judiciary in the first place, but it has nonetheless governed the federal judiciary for over 200 years. My fourth point is a much closer and more controversial one than the others. It is that a very strong case can be made that a requirement of complete diversity cannot constitutionally be imposed by Congress, even if it were inclined to do so. And that strong case was made by a figure no less than Joseph Story in Martin against Hunter's lessee. My time has expired, and so, Mr. Chairman, I'll refer the subcommittee to my discussion of those constitutional issues in my written testimony. Thank you very much.
Thank you, Mr. Cooper, and I'll now recognize Professor Shepard for 5 minutes.
Thank you, Chairman Franks, Ranking Member Cohen, and members of the subcommittee for the opportunity to testify today. My research focuses on empirical analyses of the civil justice system and the judiciary. Today, I will discuss one of my recent studies that examines the impact on federal court caseloads of an expansion in diversity jurisdiction. Research suggests that the bias recognized by the original framers against out-of-state litigants and corporations persists today. Surveys of attorneys indicate that bias based on residency status or corporate status continue to be the primary rationales for seeking a federal forum over a state forum in diversity cases. The intensifying politicization of state courts and state judicial elections likely account for some of the present judicial bias in state courts. Approximately 90% of state court judges must be re-elected by voters, and in the last several decades, these elections have become more competitive and contentious, with aggressive campaigning and significant spending. A substantial body of empirical research, including much of my own work, has shown that state judicial elections lead judges to decide cases in ways that will get them reelected, and this includes favoring in-state litigants who are voters over out-of-state litigants. Despite this evidence of bias, some commentators have argued that expanding diversity jurisdiction would place an impossible burden on the federal courts. My study addresses this question by estimating the impact on federal caseloads of replacing complete diversity with the minimal diversity standard required by the Constitution. To determine the impact of moving from a complete diversity standard to a minimal diversity standard, the study compiled data from several different sources. First, a team of independent researchers from Emory University collected and coded data from almost 3,600 complaints filed in the state courts in 2013. Additional data were compiled from federal court caseloads, data on diversity cases in federal courts, data on removal statistics to federal courts, and data on state civil court filings. The results from the 3,600 coded complaints showed that about 7.5% of the cases were removable under the current complete diversity standard. An additional 6.3% of the complaints would be removable under a minimal diversity standard. However, the majority of cases that satisfy the current complete diversity standard are not filed in federal court, nor ever removed to federal court. There are numerous reasons why diverse litigants that do not fear local bias may prefer to remain in state court. To mention a few, many state courts have established positions in an area of law, and defendants prefer the certainty of state court over the uncertainty of federal court. Some state courts and judges, such as specialized business courts in the states, have special expertise that may make them more knowledgeable about certain areas of law than the federal courts. Defense counsel may have closer contacts and stronger relationships to both state court judges and attorneys. In cases involving individuals or small businesses, the convenience and lower cost of state court may deter removal to federal court. And finally, a defendant such as a large local employer might assume that potential local bias in state court, either judicial or political, may actually work in its favor. Indeed, existing federal data on removal statistics reveals that of the 7.5% of the complaints in our study that were removable under complete diversity, the majority, about 97%, would never be removed. Next, I applied the actual removal rate under complete diversity to the number of potentially removable cases under minimal diversity. My co-panelist questions whether this is a safe assumption to make, to assume that the percentage of removable cases that are actually removed under complete diversity will be the same percentage that is actually removed under minimal diversity. I agree that this is an assumption. Unfortunately, assuming is all we can do because we don't live in a world with a minimal diversity standard. However, there's no reason to think that the removal rate will be higher under minimal diversity. If anything, it should be lower. Because some of the new cases will have plaintiffs and defendants that share a domicile, the advantages of keeping the cases in state court that I just detailed will be even more likely to exist. Convenience, lower travel costs, favorable local bias, and close relationships with judges and attorneys are more likely to convince these defendants that do not fear local bias to stay in state court. Thus, if anything, the percentage of cases that are actually removed should decrease under minimal diversity, not increase. But assuming that the removal rate stays the same, the data revealed that approximately 13,900 additional cases would be removed annually to federal court under a minimal diversity standard. This represents only a 7.7% increase in federal court caseloads. And while this 7.7% increase seems like a small burden, the burden could be further reduced by increasing the amount in controversy requirement to a level above $75,000. Or alternatively, filling existing judicial vacancies or expanding the number of federal district court judgeships, which has happened 10 times since 1960, would also alleviate this burden. Thank you again for the opportunity to speak to you today.
Thank you, Professor. Mr. Whitechie.
Good morning, Chairman Franks, Ranking Member Cohen, Full Committee Ranking Member Conyers, and members of the subcommittee. My name is Ronald Weich. I'm the Dean at the University of Baltimore School of Law, and I appreciate the opportunity to testify today. The subject of today's hearing, federal diversity jurisdiction, is very technical, but as has been noted by the members of the committee, it is very important. It implicates core principles in our constitutional system: state sovereignty, the proper functioning of the federal courts, and questions of federalism. And the importance of the subject lead me to urge, above all, that the committee proceed with great caution. This is potentially a powder keg for the federal courts and for our system of federalism. And if the committee wants to explore, as the title of the hearing suggests, federal diversity jurisdiction, that's fine. But to legislate in this area would require far more consideration. And specifically, I would urge that you consult with key stakeholders and subject matter experts across the spectrum. I am not myself a civil procedure professor. I don't teach federal jurisdiction. As the dean of a law school, I have a certain perspective that I'll share with the committee today, but I would urge that subject matter experts in this very technical area be consulted before any legislation is advanced. I want to address several issues, starting with Strawbridge against Curtis, which Mr. Cooper referred to, the 1806 decision by Chief Justice Marshall. Mr. Cooper is a legendary litigator. I respect him greatly, but I fear that he has taken on mission impossible here, trying to convince Congress to overturn a decision by Chief Justice John Marshall from 210 years ago. Not only has the Supreme Court not overturned, never seriously questioned the holding in Strawbridge that Article 3 requires complete diversity, but Congress has never come back to that question in a significant way, and I'll describe that in some detail. You know, I looked, after reviewing Mr. Cooper's testimony, I went back last night and using my somewhat atrophied legal research skills, I wanted to see whether Strawbridge had been questioned in Supreme Court cases in these 210 years, and it really has not in any significant way. There are decisions from the 19th century, the 20th century, and as I cite in my testimony, the ExxonMobil versus Alapata case in 2005, where the Supreme Court says we adhere to the principle of complete diversity. Meanwhile, Congress, which could have imposed a different diversity standard, hasn't done so. In fact, it's done the opposite. The Congress has repeatedly raised the amount in controversy threshold to make diversity jurisdiction less available, and Congress has taken other steps to limit rather than expand federal diversity. One exception to that is, of course, the Class Action Fairness Act of 2005, And that seems to me to be a cautionary tale. I've heard that there are practitioners and judges who feel that that law allowed too many cases into federal court. Perhaps there are defendants who fear that it doesn't go far enough, and that might be a fit subject for consideration. But that's far, far from the very dramatic step of changing complete diversity to minimal diversity. In my testimony, I point out that Congress has, for 210 years, largely restricted diversity jurisdiction for 3 reasons, which have been highlighted by members of the committee already. Number 1, state sovereignty. Number 2, litigation costs. And number 3, the proper functioning of the federal courts. On state sovereignty, it must be emphasized that these are state law claims arising under state statutes or state common law, and it is quite a dramatic thing from the perspective of federalism to say that a federal court, not accountable to the citizens of a state, should adjudicate those claims. And it's really ironic that I know many members of this committee have long championed the principle of state sovereignty and states' rights, and it seems odd that now you would move in a different direction in this area. I speak in my testimony about the Maryland judiciary, which I know well, which is very well equipped to handle these cases, and I know you have on this committee a former state court judge, Judge Gomert, who knows well the state judiciary in Texas. I point out in my testimony that the exercise of diversity jurisdiction tends to increase complexity and costs, and I highlight, for example, the problems that are created when a federal court has to certify a question to state courts. It can take years for that to be resolved. And then finally, the federal courts, where, as has been pointed out, the caseload has increased, there are fewer judges. My distinguished co-panelist, Professor Shepard, says it would only be 7.7% of an increase in the caseload. That's a dramatic increase for federal judges, and I fear that if we're simply assuming, because past is present, that that's not going to be a very comforting assumption for federal judges and administrators who would be looking at really an ocean of new cases coming into the federal courts. So for all these reasons, I would urge the committee to proceed with great caution before expanding federal diversity jurisdiction.
Thank you, Mr. Weich. I would now thank all of the panel members for their testimony. We'll proceed under the 5-minute rule with questions, and I would begin recognizing myself for 5 minutes. And Mr. Cooper, I'll direct my first rather basic, sort of the blooming obvious award question to you. What do you think the implications are of your argument for federalism? And I'll put it a little differently. Do you think that a minimum diversity standard is a violation of states' rights, and that the founders, framers, somehow got the wrong balance?
Chairman Franks, I do not. And, you know, I come to this issue as somebody who I think has a reputation, if you will, but certainly a pedigree of being very, very protective of federalism, principles of federalism, state rights, not only in my early time in the Reagan administration Justice Department, where some people called me the federalism cop of the administration, but also in my private practice, where I've represented a number of states and did in every way to zealously protect those reserved rights under the 10th Amendment. But my research into this subject matter has completely satisfied me that this is one of those provisions of the Constitution that quite carefully and deliberately created a path, if you will, into neutral federal tribunals for interstate disputes. The necessity of a neutral federal tribunal to resolve interstate disputes of national importance was viewed by all of the founders as a necessary a feature of the federal government's power to regulate interstate commerce, and of all the other substantive provisions, Chairman Franks, that were designed to ensure a national commercial network. And so I do not believe, I believe in fact that our federal system depends as much on the federal courts having diversity jurisdiction over large interstate disputes as it does that this body, Congress, have regulatory power over interstate commerce. They go hand in hand.
Sir. Well, thank you, Mr. Cooper. And now I'd like to ask Professor Shepard on this issue of local, quote, bias. I know one of your areas of interest is the empirical research concerning bias in general, especially in contemporary state court litigation against out-of-state defendants. And what are the principal findings that you've had in that regard?
Well, I could go on and on. This is a big area of my research and others as well. But the research generally shows that in the majority of states, there's 3 states where judges have permanent tenure, like in the federal system, but the other 47 states, they don't. And they're selected and retained through a variety of methods: elections, appointed, merit selection. But in all of these systems, there is a real problem of bias. There is a problem of certain kinds of judges being more likely to be put on the bench and then be retained based on the way that they vote. We find that the campaign money matters a lot for who wins and then who stays on the bench. We find that contributions from certain groups are very correlated with the way those judges vote. So judges that receive more money from Group X are more likely to vote in favor of Group X. And we've seen in Shepard v. Massey, we saw the Supreme Court take this issue up for the first time and recognize that there is a risk of real bias, but we still have recusal systems that are not really in place to protect the litigants. And so there's just an overwhelming body of evidence that I could produce this high for you that would suggest that there's a lot of bias in the state courts today.
Well, thank you. I'm going to now turn to our ranking member and recognize him for 5 minutes for questions.
Thank you, sir. Professor Shepard, you have been in favor of having additional federal courts created, and that the backlog that we've got in the Senate, you mentioned in your testimony, that could end. Have you written any letters to the members of the Judiciary Committee urging them to approve the district court judges who are sitting before them?
No, I have not.
You haven't taken that step. 7.7% is a pretty large increase, really. I mean, they're behind as is. How can you, that's your figure. It could be greater, it could be lesser. Without the Senate acting and approving the nominees of the president or increasing judges, how could this work?
No, I mean, I agree that given the current situation where we have a lot of vacant judgeships, that does represent a problem. I mean, hopefully those vacancies will be filled. They have been slowly, little by little. In terms of expanding the number of judgeships, that's happened 10 times since 1960. We were at a number down near 200, and now we're at 667. So it's not that crazy of an idea that we might increase that. But of course, you're right. We would have to not only create new judgeships, but actually fill the vacancies as well. I think another idea that might make a lot of sense and certainly has more of a background is increasing the amount in controversy from 75,000 to some higher amount. And then we would be limiting not just the new cases that would satisfy the minimal diversity standard that would go forward, but also some of the current cases that satisfy complete diversity. There'd be some of those that would no longer be removable as well.
Your statements about the state courts and the idea that sometimes they don't take the cases to federal court because they got a judge they like or something, and they get a favorable, and that money has and I don't say it doesn't. What's your position on Citizens United?
I think Citizens United has, I think it's the way it treats judicial elections should be separated from the way it treats other elections, but I have written very publicly against Citizens United as it applies to judicial elections.
How about non-judicial elections where people approve judges and might be influenced by the money they receive from certain groups?
That's not, I mean, all my research is really just focused on the issues in state judicial elections, so I don't really feel qualified to answer that.
Just curious, have you been paid anything by the National Association of Manufacturers at any time in the past?
They paid for the coding for the researchers. That it costs a lot to hire a team of researchers to code this, and as with a lot of my work, that the actual coding projects are funded by some other group. Like a lot of my judicial work is funded by the American Constitution Society. The coding projects are. This coding project was funded by NAM.
And how much did NAM pay you for doing that work?
Pay me or pay the researchers?
Paid you.
I would have to look back through. It was 10 researchers. They make, $12 to $15 an hour. I don't recall the exact numbers. I would have
So
to look back
you didn't
through.
get paid? Just the researchers got paid?
The researchers got paid, and there was a small amount for my time, but the majority of it went to the researchers.
How much was that small amount?
I would have to. I'm sorry, I don't recall.
Was it as much as the $105,000 consulting fee from the American Tort Reform Association for your work there?
No,
Wasn't that much, okay.
no.
You wrote an article, and I don't know what it is, but the title of it intrigues me, about baseball's accidental racism, the draft, African-American players in the law. Would you tell me what that was about? I'm a baseball fan.
Oh my, yes, I'm going to probably get it wrong, and I apologize. It's been over a decade. I was actually an econ professor when I wrote that. I was good friends with Nolan Ryan, with the scout Red Murph, who was who drafted, I guess, or whatever the verb at that point was, Nolan Ryan, and he used to talk about how back in his day when he was a scout, things were completely different, and he found Nolan when he was 14, worked with him, had him out to his ranch every summer. I grew up in Texas, and when it came time for Nolan to sign with the team, he went with who Red said should be, the best team. And then he said the draft just did away with all of that. There was no incentive to invest in a player because they could sign with any team. You had no say over that. And he said it's really harmed a lot of the lower income groups, including at the time a lot of the minority groups. And so it was just an empirical analysis confirming that the draft did have these negative impacts on certain lower income groups because scouts no longer had the incentive to really work with and invest in the skills of players.
Thank you. There's been a decrease in African-American players in the major leagues, and part of it's because of opportunity costs that football and basketball seem to take, but I think it's been an unfortunate situation because it's America's sport and it should be more reflective of our populace and Willie Mays' great talents. I yield back the
Thank you.
balance.
I will now recognize the Vice Chairman of the subcommittee, Mr. DeSantis, for 5 minutes.
Well, thank you, Mr. Chairman. Thanks to the witnesses. So, Mr. Cooper, is it the case that you think that if Congress were to legislate a minimal diversity, would that be constitutional? I mean, I guess I know you would argue that it would be in terms of original principles, but we would have to get a favorable Supreme Court decision. They would have to reevaluate this, and the courts too?
No, Congressman DeSantis, I honestly don't think there's anyone who doubts Congress's ability to legislate minimum diversity. The harder question is whether Congress would have authority to legislate complete diversity if that's what it decided to do. But the burden of my testimony is that it never did decide to do that in the original 1789 Judiciary Act. The language was very closely similar to Article 3, Section 2, and the interpretation in Strawbridge that requires complete diversity is something that strains the language itself, and it adds a restriction that the language just doesn't imply, and certainly none of the history. And the court itself, or the author of the court, and a majority of the members later came to think it was wrongly decided. But I don't think anyone doubts, really, that Congress has, because the Constitution itself does not require complete diversity, Congress has the ability to legislate minimal diversity. And it did, as I think the ranking member mentioned in his opening remarks, or perhaps it was Congressman Conyers, I'm sorry, referencing CAFA, the Class Action Fairness Act, where complete diversity was significantly relaxed.
Now, a lot has changed since the 1789 Judiciary Act, particularly in the legal profession, particularly when you talk about some of the massive cases that can be brought. And I think you allude to this in your testimony. Plaintiffs really can go anywhere in the country, so to speak, and find specific jurisdictions that have a track record of being very friendly to certain cases. I think you cited this one place in Illinois where the asbestos cases all were brought, even though most of the plaintiffs never have any connection to Illinois. So how would what you're proposing change that dynamic, and would changing that dynamic be better for the economy?
Yes. Well, relaxing the complete diversity requirement would change that dynamic by allowing the removal of cases where there is diversity, minimal diversity, to federal court. The original, I would submit to the subcommittee, the original intendment and understanding of the purpose and the operation of the diversity clause in Article 3, Section 2. As you mentioned, there are a number of state court jurisdictions where literally hundreds of cases, for example, Madison County and the asbestos cases, fewer than 1/10 of the cases in those state courts in Madison County do the plaintiffs have anything to do with, or the defendants for that matter, have anything to do with the jurisdiction by way of citizenship anyway. And this would permit that kind of clear gaming of and forum selection for the reasons that Professor Shepard has outlined to be frustrated by ensuring that those cases, which are, very large interstate disputes among very large concerns, could be removed to a federal tribunal.
And is I guess the implication that there are certain state courts that have developed kind of a reputation of being very conducive for certain types of cases, that if you remove that to an Article 3 court, that it would be, I guess, less friendly for some of the lawyer-driven major litigation?
There is a reason that these cases, usually mass tort cases, but other kinds as well, these interstate disputes concentrate in particular state jurisdictions. There's a reason for that. The plaintiff's lawyers select those jurisdictions. There's a reason for that. I think we've heard testimony thus far to explain that phenomenon. And if the federal jurisdiction in those areas was available on a minimal diversity basis, even if significantly restricted by an increased amount in controversy, for example, then I think those kinds of forum shopping abuses really would disappear.
Thank you. My time's expired. I yield back.
I thank the gentleman. I now recognize the ranking member of the full committee, Mr. Conyers, for 5 minutes.
Thank you, Mr. Chairman. I thank the witnesses for their discussion here. I'm going to, since Professor Weiss has not been asked a single question yet, I'll break this void and ask him about the estimate made by his co-panelist, Ms. Shepard, who estimates that 557,000 cases would become removable, which is twice the current civil federal caseload. She's hoping that only 2.5% of them will actually get removed. But what would happen if more were removed? What, in your view, would be the impact on federal courts, sir?
Thank you, Congressman Conyers, for that question. First of all, as to the estimate by Professor Shepard, she says, assuming is all we can do, and I understand that it's an assumption based on social science principles that she has applied here, but it is a very scary prospect that based on that assumption, a change would be made to law that might increase the federal caseload so dramatically. As you say, there are over 500,000 additional cases that she has found that could end up in federal court. And one point to make here is that because these are multi-defendant cases, if Congress were to move to a minimal diversity standard, any defendant could make that choice. Even if other defendants didn't want to see the case removed to federal court, there'd be more decision makers, and so you would see, I think, there's reason to fear that there would be more than only 7.7%. But even if it were that, that is a very large increase for an already overstressed federal court system. And again, these are state law cases. It's not just the number, it's the kind of cases. Federal judges aren't principally responsible for knowing state law. They have to master it in particular cases here. Sometimes state law is unclear and they have to seek certification from the highest state court in which they sit. There's tremendous complexity about which state law is to apply, whether supplemental jurisdiction attaches. For all these reasons, there are costs that are associated with increasing and expanding federal diversity jurisdiction. And for these reasons, at the very least, Congress should move slowly, but in the end, I think it would be unwise to expand this category of federal jurisdiction.
Thank you so much. Does eliminating the complete diversity requirement raise any federalism concerns, given that its elimination may allow federal courts to play an even larger role in deciding purely state law claims?
It does. I assume that question is directed to me, Congressman Conyers, and I feel that it does raise state sovereignty concerns in a very significant way. And in part, there is not just the abstract balance between federal and state, it's how state courts are viewed, and the talk of bias and judicial hellholes, I think really is a disservice to the hardworking, highly professional state court judges. In 1789, at the framing of the Constitution, the first Judiciary Act, and in 1806 when Chief Justice Marshall decided Strawbridge, the country was more factionalized. One had reason to question whether state courts had loyalty to the federal government. There's no question. We have fought wars to ensure allegiance to the federal Constitution, and there is no doubt, and I tell you every day I deal with Maryland state court judges who are deeply committed to doing their jobs and adhering to and enforcing the federal Constitution and federal rights. There's just no reason to think that the state judiciary in general is incompetent or biased or incapable of handling their responsibility to apply state law.
Thank you. Related to that in a way is the consideration of the impact that might occur with the elimination of the complete diversity rule would have on the costs for litigants seeking to file claims in state courts. Could that be significant?
Yes. I mean, I'm interested to hear Professor Shepard say that she thinks not many cases would be removed because many parties in state court appreciate the convenience and lower cost of litigating in the jurisdiction in which they sit. If all that is true, then expanding federal jurisdiction and allowing defendants to remove cases to federal court will, I think, increase costs and limit convenience and take disputes out of the local fora in which they belong.
Thank Chairman Franks.
And I thank you, sir, and I would now recognize the gentleman from Texas, Mr. Gomert, for 5 minutes.
Thank you, Mr. Chairman, and we appreciate the witnesses being here. And I do find it interesting the discussion about bias. I was wondering, Professor Shepard, do you have empirical studies and data about bias in federal court?
No, I mean, I haven't done any of that work, but there is some studies that mainly just looks at the relationship between ideology and the way federal court judges rule, and as you can imagine, there is a linkage there. Judges appointed by Republicans tend to vote differently than judges that are appointed by Democratic presidents, but importantly, it's not because they don't have to be retained or run for re-election or reappointment. It's different, and it's based more on this kind of fundamental, predictable ideology than it is who's giving money to the campaign.
It is interesting to observe, though. I can't recall anyone ever appointed to federal court, and especially the Supreme Court, that was touted as a liberal who took to the court and became immensely conservative, but certainly it's happened the other way.
Hey, Bob.
But I do want to reiterate something Mr. Welch has said about having worked as a prosecutor, but for a much longer period as a civil litigator in both state and federal courts, from MDL litigation, all kinds of litigation, and having appeared in front of different federal courts and state judges, having been a state district judge and a state appellate court judge, I found a tremendous amount of bias in federal courts, and that is obviously why you have people who have learned how to game the federal court system by filing multiple suits and hoping the case comes up in the federal court judge they want and then dismissing others. I mean, it's become quite a game. I also saw great disservice to people who had complaints about benefits from their employment that got removed to federal court, and there became an end of their righteous claim. I've seen a great deal of injustice that was not occurring at the state court level that did occur at the federal level. So I think that's worth keeping in mind. And when people talk in terms of, gee, it's terrible for states like Texas that elect their judges, much better if you have judges appointed. It seems like to me there is equal pros and cons. I've seen massive abuses from people who sought their appointment, played the political game, got their appointments, and then became far more political than somebody who had to stand for election and appear to be fair to all sides. So anyway, it's interesting, the studies, the empirical data you refer to from state courts that doesn't appear to be done for federal courts, and yet experience shows there's an awful lot of bias in federal courts that is not being talked about. Well, I appreciate your testimony today. You've provided data that I'm going to have to look in and do some cross-referencing myself, but it's an interesting issue, and I appreciate all of you bringing it to our attention. Thank you. I yield back.
And I thank the gentleman, and I now recognize the chairman of the Judiciary Committee, Mr. Goodlatte, for 5 minutes.
Well, thank you, Mr. Chairman. I appreciate your holding this hearing. I appreciate the testimony of the witnesses, particularly from my good friend Chuck Cooper. It is great to see you here with us, and I'm going to just briefly share some of my thoughts about this issue. Federal court diversity jurisdiction might seem dry and technical at first blush, but it's actually near the heart of the founders' vision of the body politic, namely their understanding that federal courts should hear cases between citizens of different states, especially when those lawsuits involve commercial or other subjects integral to the national economy. Currently, when a citizen from one state sues a defendant from another state, the interstate nature of that lawsuit gives federal courts jurisdiction over the case. While the Constitution provides that Congress can grant federal courts jurisdiction over all such cases, cases involving what lawyers refer to as minimal diversity, a glitch in current statutory law allows trial lawyers to forum shop and keep their cases in the state courts they prefer if they sue a defendant from another state and simply also sue an additional local defendant in the state in which they're filing the case. Not surprisingly, these rules have been abused by trial lawyers who sue local defendants, even though the plaintiff's claims against those defendants have little or no support in fact or law, because suing those local defendants allows trial lawyers to keep their case in a preferred state court forum. This committee reported out, and the House passed earlier this year, the Fraudulent Joinder Prevention Act, which would limit this abuse. And just over a decade ago, I was the chief sponsor of the Class Action Fairness Act, which was enacted into law in 2005. As many people have noted, including current Seventh Circuit Court of Appeals Judge Diane Wood, that legislation addressed the same problem in the context of class action lawsuits. In the conference report on that law, Congress was explicit about its view of the purpose of diversity jurisdiction and the need in multi-state class actions to close another aspect of this jurisdictional loophole. The conference report commented, for example, that one of the primary historical reasons for diversity jurisdiction is the reassurance of fairness and competence that a federal court can supply to an out-of-state defendant facing suit in state court. The report went on to describe the many reasons the Constitution extends federal court jurisdiction to lawsuits involving citizens of different states, even when questions of state law are at issue. Among these reasons are that citizens in one state might experience injustice if they were forced to litigate in out-of-state courts, that the availability of federal courts would shore up confidence in the judicial system by preventing even the appearance of discrimination in favor of local residents, and that the option of going to federal court would guard against the possibility that the state courts might discriminate against interstate business and commercial activities because diversity jurisdiction is itself a means of ensuring the protection of interstate commerce. The conference report section entitled National Class Actions Belong in Federal Court Under Traditional Notions of Federalism makes clear that it's unfair to have one state court dictating to 49 others what their laws should be, that it's unfair to maintain a system that allows state court judges to dictate national policy, and that the existing system often allowed one state court to issue rulings that flatly contradicted the law of another implicated state. The committee report on the Class Action Fairness Act concluded as follows. The federal courts are the appropriate forum to decide most interstate class actions because these cases usually involve large amounts of money and many plaintiffs and have significant implications for interstate commerce and national policy. By enabling federal courts to hear more class actions, this bill will help minimize the class action abuses taking place in state courts and ensure that these cases can be litigated in a proper forum. Today, this hearing is about whether those same principles should apply more broadly to provide for justice and fairness in even more contexts and situations involving multiple states and national interests. So I thank the witnesses again for their contribution today, and I yield back.
And I thank the gentleman, and couldn't have said it better myself. And this concludes today's hearing, and I want to thank all of our witnesses. I want to thank the audience and certainly the members. And without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, this hearing is adjourned.
Thank you, Mr. Chairman.